You are actually applying different principles for different set of people. This is what is troubling. And had it been that after violating the 144 restriction, you take steps against the violators, that is one. You don't. They violate it with impunity. Somebody else goes, you say, no, it's not done.
Milord, could I say this, Milord, with
Yes.
utmost humility, Milord?
গত বছরের অক্টোবরে রাজভবনের সামনে তৃণমূলের কর্মসূচি নিয়ে পুলিশ কোনো পদক্ষেপ গ্রহণ করেনি। কলকাতা হাইকোর্টে জানালো রাজ্য। মঙ্গলবার রাজ্যের অ্যাডভোকেট জেনারেল কিশোর দত্ত জানান, ওই কর্মসূচি নিয়ে পুলিশ কোনো ব্যবস্থা নেয়নি। বিচারপতি অমৃতা সিনহার প্রশ্ন, কেন পদক্ষেপ গ্রহণ করা হয়নি? যদি আপনারা নিজেরা আইন না মানেন তবে অন্যরা কেন মানবে? তাদেরকে কি বলবেন? হাইকোর্টের নির্দেশ, কতক্ষণ কর্মসূচি করতে চান শুভেন্দু অধিকারী তা আদালতকে জানাতে হবে। আগামী বৃহস্পতিবার এই মামলার পরবর্তী শুনানি। ঘটনাচক্রে গত বছর 5 থেকে 10 অক্টোবর তৃণমূলের সর্বভারতীয় সাধারণ সম্পাদক অভিষেক বন্দ্যোপাধ্যায় 100 দিনের কাজের টাকা নিয়ে কেন্দ্রের বঞ্চনার বিরুদ্ধে রাজভবনের সামনে ধর্নায় বসেছিলেন। আদালতে সেই কর্মসূচির কথাই বলা হয়েছে। চলতি মাসে লোকসভা ভোট পরবর্তী হিংসা মামলায় আক্রান্তদের নিয়ে রাজভবনের কাছে কর্মসূচি করতে চেয়েছিলেন বিরোধী দলনেতা শুভেন্দু অধিকারী। পুলিশ ওই অনুমতি না দেওয়ায় হাইকোর্টে দ্বারস্থ হন তিনি। বিচারপতি সিনহা রাজভবনের পরিবর্তে বিকল্প জায়গার নাম দিতে বলেন। গত বৃহস্পতিবার শুভেন্দু অধিকারীর আইনজীবী জানান, রাজ্য পুলিশের ডিজির অফিসের সামনে ধর্ণা দেওয়ার অনুমতি দেওয়া হোক। ভবানী ভবন ও নবান্ন এই দুটি জায়গায় ডিজির অফিস রয়েছে, যে কোনো একটি জায়গায় শুভেন্দু অধিকারী অনুমতি চান। কিন্তু তাতেও আপত্তি জানান রাজ্যের আইনজীবী। শুভেন্দু অধিকারীর আইনজীবী বিল্লদল ভট্টাচার্য আদালতকে জানান, রাজভবনের অদূরে শুভেন্দু অধিকারী যেখানে ধর্নায় বসার আর্জি জানিয়েছিলেন গত অক্টোবর মাসে, সেখানেই ধর্নায় বসেছিলেন তৃণমূলের নেতৃত্বের একাংশ। এরপর তৃণমূলের অক্টোবরের কর্মসূচির প্রসঙ্গ তুলে বিচারপতি সিনহার মন্তব্য, রাজভবনের সামনে কেউ পুলিশ নিয়ে গিয়ে ধর্না দিচ্ছেন, তারপরও পুলিশ তাদের সরিয়ে দেয়নি। ওই একই জায়গায় অন্যরা কর্মসূচি করতে গেলে মারধর করে তুলে দেওয়া হয়। অর্থাৎ একটির ক্ষেত্রে আপনারা কি ইচ্ছাকৃতভাবে কোনো পদক্ষেপ গ্রহণ করেননি? রাজ্যের উদ্দেশ্যে বিচারপতি সিনহা বলেন, রাজভবনের সামনে 144 ধারা লঙ্ঘন করে ধর্ণা দিলেও কোনো পদক্ষেপ গ্রহণ করা হবে না। এরপরে ওই জায়গায় অন্য কেউ কর্মসূচি করতেই চাইবেন। আইন শৃঙ্খলা নিয়ন্ত্রণ করা রাজ্যের দায়িত্ব, রাজ্য তা এড়িয়ে যেতে পারে না। আপনাদের এই পদক্ষেপ কাউকে রক্ষা করতে চাইছে বলে মনে হচ্ছে। রাজ্যকে হাইকোর্টের নির্দেশ, রাজভবনের কতটা এলাকা জুড়ে 144 ধারা রয়েছে। উত্তর দিকের গেট থেকে 10 মিটার দূরে ওই ধর্ণা কর্মসূচি করা যাবে কিনা তা আদালতকে জানাতে হবে।
On behalf of the petitioner, my lord, on the last date, my lord, I have conveyed to the learned advocate general, my lord, the two venues, my lord, insofar as, my lord, the demonstration, the place of demonstration is concerned, my lord. We said that, my lord, the West Wing, the director of police, my lord, he has two offices, my lord. One in, my lord, Novanno, the other one is in Bhavani Bhavan, my lord. So any one of the two, my lord, sites, my lord, that's right. Now, this was what I had conveyed, my lord, and
Milord, we are offering them 4. One is already there,
No, no.
Milord, Y channel. The other is below Gandhi statue. The third is Shohid Minar, the mostly used place. And the fourth is, Milord, Matungini Haja statue. All are, Milord, within, say, maybe 2 square kilometers from, Milord, the Raj Bhavan. Because they intended initially in front of Raj Bhavan.
my lord, this comes with a rider, my lord. My lord, the state was to come and apprise the honorable court as regards, my lord, the steps which has been taken owing to, my lord, the illegal demonstration which was undertaken by the Trinamool Congress in the month of October 2023.
Milord, I'll tell your lordship, no steps have been taken.
My lord, if no steps have been taken, my lord, I
Therefore,
have
he
a
doesn't get a right.
no, I have a better case, my lord. Because why I'll tell your lordship, my lord. Now, my
But
lord,
why has steps not been taken? If you cannot rule your members,
20
then how will you rule others?
Milord,
First, there was no request sought for, permission sought for conducting the sit-in demonstration. Somebody just goes and by force sits over there. The police does not take steps to remove them. And when XYZ goes at the same place. Then they are beaten, assaulted, and whatnot. Why this
I
discrimination?
don't think, my lord, here, my lord, this has happened. That somebody has
But
been
kindly
beaten or
records, my
assaulted.
lord, that no steps have been taken, my lord. I have a better
Yes,
case to argue then, my lord.
I'll argue,
That
I'll argue.
I have an indefensible right also, my lord, in terms of the law which has
And
been laid
still
down.
now, you do not intend to take any steps. Do you intend to take steps for violating the orders of 144 CRPC?
My lord, your lordship may kindly consider, my lord, what is the case over here?
No, we will consider. He alleges discrimination. That is the first thing.
Grateful.
There cannot
That
be any
is the
discrimination.
that
Because
is
he
the
cannot make a
complaint.
submission. He cannot make a submission from the air. My lord, in order to make a submission that he has been discriminated, first, my lord, he has to demonstrate that he has a right. Let him do that, my lord. Or, my lord, if I may, my lord,
But
place my
I'll place my case, my
Well,
lord, in that event, my lord.
in
So, my lord, I proceed with the presumption, my lord, that no steps have been taken owing to, my lord, the demonstration which was undertaken by the Trinamool Congress in front of the governor's house in the month of October 2023, my lord. I had also, my lord, sought for information under the Right to Information Act, my lord, from the my lord, State Public Information Officer, Kolkata Police, my lord, on 6th of October 2023. There was a categoric query also that since the media has also reported that the proposed demonstration speaks about assembly of 1 lakh TMC workers, what are the security measures which are being undertaken? Now, despite that, my lord, till date, no information has come, my lord, on the basis of the RTI application just that was addressed, my lord, on behalf of the petitioner. Now, my lord, first and foremost, my lord, there will be a query of the Honorable Court as regards the consequences of violating an order under Section 144 of the CRPC. Now, 144 of the CRPC, first is, my lord, Section 188, which again is a cognizable offense. Table to follow CRPC. Section 188 is a cognizable offense that speaks about violating any order which has been promulgated. That apart, Section 141, my lord, kindly takes the IPC ones. IPC बताओ भाई. I'll just hand it up to your lordship. Section 141,
এগুলো না আমার হাতের কাছে রাখবেন, তা নাহলে আমার অসুবিধা হয়।
it speaks about unlawful assembly
এখানে বইটা রয়েছে কিন্তু ক্রিমিনাল মাইনর অ্যাক্টস
of the IPC.
না, মাইনর না, মেজর অ্যাক্টস ক্রিমিনাল ম্যানুয়ালটা দিন।
My lord, I've handed over my copy, my lord. In a few weeks' time, my lord, the IPC may not also be necessary, my lord. The new law will be coming into force. So 141 kindly takes the third, the third rider. The third rider categorically speaks about violation of any lawful order. So that lawful orders mentioned, my lord, will find at section 188. My lord, kindly reads it, my lord, in light of section 188 of the IPC. এটার মধ্যে এটা সেট আউট করে মানে আইপিসি পড়েছে
Yes.
and that apart also there is another violation under the fifth rider of section 141. So these are all my lord will find from the table. I'll just place from the table of the as contained in the CRPC in the first schedule. Now 141 attracts, my lord, offences under section 142, 143, 149 also, my lord. So 143 is a cognizable offence. 149 is again a cognizable offence. And 188 also is a cognizable offence. My lord, may kindly take the schedule, my lord,
Yes.
to the CRPC. Schedule টা দাও।
একটু উঠুন, বাঁ দিক থেকে 3 নম্বর বইটা দিন, এদিকে ক্রিমিনাল ম্যানুয়াল রয়েছে। ইয়েস, ব্লু কালার। হ্যাঁ হ্যাঁ হ্যাঁ, ঠিক আছে, দিয়ে দিন বই ফেরত।
Now, the law is very clear, my lord, that when it comes to cognizable offences, the police has to act.
What are the sections you are relying
My
upon?
lord, I am referring to section 141, the third rider, which says It is about unlawful assembly. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons comprising that assembly is to commit any mischief or criminal trespass or other offense. And thereafter, the fifth rider also, by means of criminal force or show of criminal force, to compel any person to do what he is not legally bound to do, or to omit to do what he is legally entitled to do. Now, the movement was that we will be sitting here unless and until His Excellency the Governor agrees to meet us. It was a compulsion that we will not be moving. This particular movement will be continuing unabated and unabashed, despite presence of the erring police officers, unless and until His Excellency the Governor agrees to meet us. So this is squarely covered under the third and the fifth rider of unlawful assembly. Now, if we read it, my lord, along with section 142, 142 states that whoever being aware of the facts which render any assembly an unlawful assembly intentionally joins that assembly or continues in it is said to be a member of an unlawful assembly. 143 speaks about the punishment. Whoever is a member of an unlawful assembly shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or both. Now, if my lord kindly takes the schedule, first schedule of the CRPC, offences against public tranquility, 143 is a cognizable offence. Thereafter, my lord, section 149 again will be relevant. 149 states, every member of unlawful assembly guilty of offence committed in prosecution of common object. If an offence is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing that offence is a member of the same assembly is guilty of that offence. So it is not the case, my lord, that someone specific will be singled out. It is the person who organized the unlawful assembly as well as the participants, my lord, against whom, my lord, the legal process has to be activated, because all of them are cognizable offences, my lord. I'm not on the punishment or not on the question whether they are bailable or non-bailable. Some are bailable, some are non-bailable. And apart from that, section 188 is also very, very clear of the IPC. 188 states that disobedience to order duly promulgated by public servant, whoever knowing that by an order promulgated by a public servant, lawfully empowered to promulgate such order, he is directed to abstain from a certain act or to take certain order with certain property in his possession or under his management, disobey such direction, shall, if such disobedience causes or tends to cause obstruction, annoyance or injury, or risk of obstruction, annoyance or injury to any persons lawfully employed, be punished with simple imprisonment for a term which may extend to 1 year, or with fine which may extend to 200 rupees, or with both. And if such disobedience causes or tends to cause danger to human life, health or safety, or causes or tends to cause a riot or affray, shall be punishable with imprisonment which may extend to 6 months, or with fine of 1,000, or with both. So, my lord, there has been an express violation of an order lawfully promulgated, my lord. That is 188. Now, if we read it, my lord, in the light of, my lord, the third rider and the fifth rider of section 141, my lord, these are also offences, my lord. The provisions of 142, 143, 149 are also automatically attracted, and all of them, my lord, I reiterate for the sake of prolixity, are all cognizable offences, where the police is not having a discretion not to register, my lord, any case. They have to. They are under a compulsion, my lord. In terms of the law laid down by the Honorable Supreme Court of India in Lalita Kumari's case, my lord, they are under a compulsion. Now, my lord, comes the second question, my lord. In so far as, my lord, my legal right is concerned, my lord, the law has now been laid down in Anuradha Bhasin's case. Prior thereto, my lord, in Anindo Gopal Mitro's case, my lord, also, my lord, after the my lord, the Ayodhya issue, my lord, that took place in the early 90s, my lord. Citing 144, the Commissioner of Police had rejected permission to the Bharatiya Janata Party at that point of time, stating that no, Bharatiya Janata Party, if they organize any rally or any meeting, that will lead to a law and order situations. The High Court, the Honorable High Court, the single judge as well as the division bench, came down very heavily on the state, stating that the Bharatiya Janata Party at that point of time was the principal opposition party in the country. And there was no action undertaken for de-recognition of that particular party. So once a political party, a recognized political party, intends to exercise its fundamental right, citing 144 or citing law and order situation without citing any reason, my lord, cannot be a ground, my lord. I'll just, my lord, I'm carrying the judgments, my lord. অনিন্দ গোপাল মিত্র কোনটা দেখাচ্ছ? অনিন্দ গোপাল মিত্রটা বলছিলাম, তুমি শোনো ভাই, ফলো করো প্লিজ। If you don't follow, don't.
This is Anuradha Bhasi.
This is Anuradha Bhasin, my lord. I'll come to that, my lord. This is how the law has evolved. হ্যাঁ বলছি দাদা। অনিন্দ গোপাল মিত্র, অনারেবল সিঙ্গেল জাজের হচ্ছে 1993 1 CHN page 450, মানে 450. And this was affirmed, my lord, by the Honorable Division Bench, which is again reported in 1993 1 Calcutta Law Times, page 464. Sure. 1993, volume 1, Calcutta Law Times, page 464. Now, following this judgment, my lord, the law pertaining to section 144 orders, my lord, that has evolved, my lord. Now, very recently, my lord, now one Songrami Jautho Moncho, now they approached the Honorable High Court at Calcutta, my lord, for holding a demonstration just opposite to Nobanno, my lord. Now, on the basis of their application, my lord, and upon hearing the state, my lord, permission was granted, my lord. Since they are, my lord, government employees, they also had an indefeasible right, my lord, to demonstrate under the fundamental guarantees, my lord, as contained in Article 19, my lord, of the Constitution of India. Now, thereafter, এটার একটা কপি দাও, এটা কিশোরদাকে দিতে হবে। অমিতেশ দা অ্যাপিয়ার করেছে, একটু বার করে দাও প্লিজ ভাই।
ওটা ফার্স্ট টপে ছিল।
হ্যাঁ, জাস্ট অপোজিট টু নবান্ন। তোমার একটু অ্যারেঞ্জ করে রাখা উচিত না? Now, just
Is this place also under 144
well,
CRPC restricted?
that was what, my lord, the state possibly also argued, my lord. They went up in appeal. They went up in appeal, and the Honorable Division Bench said that since the demonstration has begun, we are curtailing the period, but we will not be staying the order, restraining them from continuing with the demonstration. Now, thereafter comes, my lord, the law as laid down by the Honorable Supreme Court of India in Anuradha Bhasin's case, judgment of and that is reported in, my lord, 2020 volume 3 Supreme Court cases, page 637. Now, this pertains to, my lord, the suspension of internet services, my lord, when my lord, Article 370 was, my lord, abolished, my lord. So now, the Honorable Supreme Court lays down certain parameters. Now, the parameter is a longish judgment, my lord. The parameters, my lord, will find page 637, page 710. My lord, kindly takes pain to come to page 710. Yes. Now, these are the parameters which are being laid down. The conclusion that starts from para 160. 160 is at page 709. Now, 160.10 and onwards, my lord, I'll just place. It states that the power under section 144 CRPC being remedial as well as preventive is exercisable not only where there exists present danger, but also when there is an apprehension of danger. However, the danger contemplated should be in the nature of an emergency and for the purpose of preventing obstruction and annoyance or injury to any person lawfully employed. Thereafter, the power under section 144 CRPC cannot be used to suppress legitimate expectation of opinion or grievance or exercise of any democratic rights. Thereafter, my lord, the order passed under section 144 CRPC should state the material facts to enable judicial review of the same. The power should be exercised in a bona fide and reasonable manner, and the same should be passed by relying on the material facts indicative of application of mind. This will enable judicial scrutiny of the aforesaid order. While exercising the power under section 144 CRPC, the magistrate is duty bound. Here it will be the commissioner, my lord. Within the city of Calcutta, the commissioner is having the powers, my lord. Is duty bound to balance the rights and restrictions based on the principles of proportionality and thereafter apply the least intrusive measure. Repetitive orders under section 144 would be an abuse of power, and the state and the competent authorities were directed to review. So, my lord, my case is that, my lord, already there is an instance of, my lord, a demonstration being held, my lord, in the place in question where the petitioner herein wants to also sit for a demonstration. We do not want to, as I indicated, my lord, construct a makeshift stage also. And I have been very fair, very candid before your lordship on the very first occasion that we are ready and willing to, my lord, abide by whatever measures, whatever, my lord, rights, conditions are imposed by the honorable court, my lord, including the duration also. If my lord says that, no, you have it on a weekend, you have it for a particular period of time, we are ready and willing to do that. Now, secondly is, my lord, there is no apprehension, my lord, of emergency. That has not been spelled out, my lord. The order impugned just states, it is dated 18/6/2024. With reference to the above, this is to inform you that your scheduled program cannot be allowed at the referred place due to administrative reasons. That is at page 26, my lord. So the order itself is cryptic, my lord. It is non-speaking. There are no reasons. It is just merely an exercise where the ipse dixit of the authority concerned, that is the Joint Commissioner of Police, my lord, that has been recorded, my lord. And I say, my lord, this smacks of arbitrariness and discrimination in as much as a person, my lord, was permitted to form a congregation of 1 lakh people, my lord, in and around that area for a continuous duration of 5 days to compel His Excellency, the Governor of West Bengal, to meet him or to meet the team. Despite which, my lord, there was no action undertaken, my lord, or the provisions of law were not activated. And it has been also, my lord, summarily admitted on behalf of the state today, my lord, that no action has been undertaken till date. We understand, my lord, nothing will be undertaken. My lord, it is almost more than 6 months. Happened in the month of October. And here, my lord, the state has not come up with the fact that no, the petitioners intend to do something very violent or the petitioners intend to sit or carry weapons or lathis. It is just a symbolic protest, my lord, a symbolic demonstration rather, as I indicated on the very first day. So, my lord, the state at the outset, my lord, has demonstrated its utter disregard to the principles of equality by trying to shield persons belonging to the ruling faction in the state at the behest of whom the law of the land is being constantly violated. And on the contrary, the state has acted stepmotherly, my lord, when it comes to the case of the petitioner, and that too for holding a symbolic demonstration, my lord, in front of, my lord, the governor's house, at the same place, my lord, where this particular demonstration was held. I say, my lord, the order suffers from reasonableness, and the order suffers from, my lord, the vices of illegality, irrationality, and also, my lord, impropriety, on the ground whereof, my lord, the order should be cancelled, my lord, and also, my lord, relying on the principles of, my lord, law laid down by the Honorable Supreme Court, my lord. It was laid down, it's also referred to, my lord, in Anindo Gopal Mitra's case, my lord, the division bench judgment, K.S. Jagannath's case, my lord. The Honorable Writ Court has every power, my lord, to, my lord, not only, my lord, to go into the decision-making process, my lord, but to pass a mandatory direction regarding, my lord, holding of the meeting on the basis of the application which has been made by the petitioner. Not a meeting, my lord, a demonstration. These are my submissions, my lord, in a nutshell, my lord. And, my lord, I further say that the state is under every obligation to activate the process of law, my lord, and to bring the offenders to book, my lord, insofar as the violation of 144 is concerned. It is admitted, my lord, there was no permission, my lord, then which was undertaken or which was applied for. There was the police authorities permitted, my lord, this particular illegality, my lord, to continue. And I am asking this question to myself, my lord, that whether, my lord, it is, my lord, the constitution permits an extrajudicial action or not, my lord. This is absolutely extrajudicial. And this is happening right, my lord, in front of, my lord. It is just on the other side of the road, my lord, where the constitutional court is situated, my lord. This should not be permitted. This is something very, very unfortunate, my lord. This is a direct instance, my lord, of a failure of rule of law, my lord, where
Yes, yes.
Grateful to you.
My lord, my first respectful submission would
On the
be
board, Dadari.
my lord, my this in the context of Miller, this writ petition, whether Miller these arguments could have been advanced or not.
Hmm.
Now, please first kindly have a look to Miller. The representation which he had made, I've taken your lordship through that Miller on the last occasion, but kindly, apropos my learned friend submissions today, Miller, kindly have a look to page 20. But I may have to deal with Miller the judgments which my learned friend have cited on a later occasion, but Miller, I am primarily ready with my answers. Please take Miller page number 20. Paragraph subject is permission to hold so and so. Then first he says that I want to hold a dharna at the same site adjacent to the Raj Bhavan where the regional so and so party were allowed. So this is Miller, the prelude to the application. That why should I do it over there? Because someone else were permitted. Then kindly take the status of the two parties, para 2 or the second paragraph. If you can allow a regional party to hold a political program at the venue, then I can see no reason why Bharatiya Janata Party, a national party recognized by the Election Commission, can't be given the same permission. So this is a might. But then comes that hope against hope that the commissioner will allow. That is the third paragraph. Then fourth, we can skip over. They say, which my learned friend have said, that there are two different rules for two groups. Then kindly take the fifth, the last paragraph at that page. If you are planning to deny us permission, citing the specific reason where we intend to hold dharna or sit-in demonstration falls under the prohibitory area around the Raj Bhavan where 144 is imposed, then kindly specify the mysterious reason. How did the provisions of section 144 evaporated in the thin air for 5 days, so and so? Kindly let me know the modalities. So therefore, my lord, first is Miller knowledge that there is a 144 imposition. Second is they say that the 144 was not imposed in the manner it ought to have been done from 5th of October 2023. This is Miller the basis of the application. Then Miller, there's a follow-up representation at page 23, almost the same. I don't want to trouble your lordship Miller with those, but primarily the same. Now please take the prayers. What are the prayers? And how much can my learned friend digress from the prayer? Please take Miller paragraph number B, prayer number B at page 15. Sashorarai commanding so and so to conscionable justice by quashing the decision of 18th of June 24 by the respondent number 3 herein affected into restraining the petitioners along with the victims of the post-poll violence from holding dharna, etc. on so and so. Then mandamus allowing the petitioner to, along with the victims of post-poll violence to hold dharna and sit-in demonstration from the afternoon of 19th. Then mandamus restraining the petitioners along with so and so to hold dharnas or sit-in demonstration from the afternoon of so and so. Then rule Naisai, then Miller interim orders. I don't think Miller those are relevant. Therefore, Miller, these are the prayers he wants a permission. The petition or Miller, the application itself, Miller, cannot be entertained because it was not a simpliciter application that you grant me permission. They bring in an instance and say that you should also allow me to do that. Now, whether Miller that can be permitted or not. First is Miller, please have a look to Miller, the age-old decision of 1969, volume 1, Supreme Court cases, page 502. But there, my lord, in the railway premises, my lord, the railway higher railway officer, my lord, had prohibited any sit-in demonstration by the employees. Therefore, the question, somebody had violated that, my lord, proceedings were initiated. Therefore, the question arose is whether 69(1) অন্য কারণ এনেছে। I'm so sorry. Please give me a moment. দৌড়ে না, দৌড়ে না। 14 নম্বরের judgment book. Please give me a moment, please.
You can read it out from there. I am here to hear it.
Very. Well, this is 1969, Volume 1, Supreme Court Cases 502. Now, the General Manager Millard had directed that holding of meetings inside the railway premises could not be done. Therefore, obviously, Article 19(1)(b) was tried to be put in action, where the Supreme Court takes note of the provisions of Article 19(1)(a) and (b). May I read paragraph 10? Kindly take paragraph 10.
Yes.
It has been strenuously argued on behalf of the respondent that the rights guaranteed under 19(1)(a), B and C are inviolable and they cannot be interfered with except in accordance with clauses 2, 3 and 4 of the said article. According to Mr. Garg, the railway workers have a right to assemble in any place they choose and give expression to their views so long as they do not disturb the work going on in the premises, and that right is guaranteed to them under our constitution. It is not disputed that the Northern Railway is the owner of the premises in question. The fact that the Indian Railways are state undertakings does not affect their right to enjoy their properties in the same manner as a private individual may do, subject only to such restrictions as the law or usage may place on them. Hence, unless it is shown that either under law or because of some usage, the railway servants have a right to hold their meetings in the railway premises, we see no basis for objecting to the directions given by the general manager. There is no fundamental right for anyone to hold meetings in government premises. If it is otherwise, there is bound to be chaos in our offices. The fact that goes to offices, then kindly take para 12. This is wider. It is true that freedoms guaranteed under our constitutions are very valuable freedoms, and this court would resist abridging ambit of those freedoms except to the extent permitted by the constitution. The fact that citizens of this country have freedom of speech, freedom to assemble peaceably, and freedom to form association or unions does not mean they can exercise those freedoms at whatever place they please. This is very important. The exercise of those freedoms will come to an end as soon as the right of someone else to hold the property intervenes. Such a limitation is inherent in exercise of those rights. The validity of that limitation is not to be judged by the tests prescribed by clauses 2 and 3 of Article 19. In other words, the contents of the freedoms guaranteed by subclauses A, B, and C, the only freedoms with which we are concerned in this appeal do not include the right to exercise them in the properties belonging to others. If Mr. Garg is right in his contention, then a citizen of this country in the exercise of rights under subclauses D and D of Article 19(1) could move around freely in a public office or even reside there unless there exists some law imposing reasonable restrictions upon such rights. The other portions I skip over, I don't think those are important for the time being. Therefore, what is important is that, as I was emphasizing on the last occasion, that the difference in the language between Article 19(1)(a), B, C, D, and E is that, this cannot be, an unrestricted, unregulated right. But these rights are, capable of, certain reasonable restriction. Question is whether it is unreasonable or not. If your lordships find that the restriction which has been imposed is unreasonable, the restriction, the quality of the restriction is unreasonable, then of course, Millard, he may come up saying that you have a right to impose reasonable restriction, but you cannot impose a unreasonable restriction. But I can give you a weird example. I impose a restriction that you can demonstrate in front of the High Court, but on one leg. You have to stand on one leg and demonstrate. That becomes an unreasonable one. So if the quality of the restriction is not unreasonable, or if it is reasonable, then Millard, there is no infraction of right. But 144 is a reasonable restriction, Millard. This has been said in very many cases. Please take, Millard, the most, Millard, talked about cases of that Ramlila Maidan. Please have a look. Please take me Ramlila Maidan, 2012, volume 5, Supreme Court cases, page 1. But here, Millard, a permission was granted to hold, Millard, some sort of a demonstration at Ramlila Maidan. But once it was found that hundreds and thousands of people have started pouring in, Millard, 144 was imposed without any notice to those demonstrators. Therefore, Millard, this matter finally went before the Supreme Court to consider as to whether, Millard, 144 could have been imposed, Millard, in the midst of a dharana or a demonstration which was permitted.
Mr. Dotto, please excuse me for interrupting you once. Page 26 is the rejection order.
Yes, Millard.
It mentions only administrative reasons,
Right, right.
which is absolutely vague.
Yes.
Why don't you give the reason as to why you are not
I'll give
permitting?
that reason. I'll give that reason. But in fact, Millard, as I
This
were,
page 26 can be set aside. You reconsider their prayer for holding a sit-in dharna demonstration, whatever expression they use, in the south gate or the north, that will be the north gate possibly,
not good.
in the north gate. And then we can see.
May I say this, Millard? Kindly permit me to say this, but before the court, I am saying that I cannot. Now, if he wants
the
a reason,
144 restrictions.
yes. And Millard, your lordship has held. Well, I am fortunate that in one matter, Millard, your lordship was pleased to hold that administrative matters do not require a reason.
So-
Unless the law requires. Well, there has to be a law.
Yes. But you know what is
Of course,
troubling?
but that was in a
the
service matter. That
Calcutta
was,
University matters.
but I think the same principles would apply.
Brother Vasim says otherwise. Now the law is settled.
I don't think so. Because you are actually applying different principles for different set of people. This is what is troubling. And had it been that after violating the 144 restriction, you take steps against the violators, that is one. You don't. They violate it with impunity. Somebody else goes, you say, no, it's not done.
Millard, could I say this, Millard, with
Yes.
utmost humility, Millard? May not be taken on record. That, Millard, I have my answers to, Millard, Mr. Bhattacharya's argument on section 188. But that argument may border in protecting somebody else's right. That is why, Millard, as a state, in this matter,
You
No,
cannot.
I
know your restrictions. You are in a sticky place right now. But then if this is what the petitioner is trying to portray, the discrimination, which you pointed out that the application was made in such a manner that someone else has been given, why will I not be given? So the first thing is discrimination. We are to address that.
right. But
He doesn't have an infeasible right to hold a dharana over there. Admitted. Negative equality, he cannot pray. Admitted. Even thereafter, you are not taking steps against those persons. Why?
Could I make one suggestion? Well, since it had fallen from your lordship, that why do I not give reasons to Mr. Bhattacharya's client? But let them make an application if they so desire. We'll give them a reason.
No, application has been made.
Application is already on record. He will not make any further application.
The date has gone. The
Yes,
application was
the
for
date
19.
has it has lapsed. When 19th of June, it's long over. Maybe a fresh date they will put in. Nothing more than that.
But my case is very simple. Had it been a case, my lord, that steps were taken against the
That is
wrongdoers,
not
my
the
lord,
case.
no,
That is not
I
the
would not have
case.
any case.
I have followed it, but at the same time, you should understand
I
that
have a
it happened
legitimate
in October.
expectation.
It happened in October.
Yes.
Now, since you want to hold a dharna, you are bringing that as an
No,
example.
no, I say I want
It
to
is
hold it
not
there.
that you came earlier
No, I
to
said
take steps against the
my lord
violators.
kindly appreciates my conduct. That was organized on the 5th of October. Immediately on the 6th of October, my lord, it is on record now. I have laid it before your ladyship, my lord. I made an RTI query. It was not responded to. So, what is the reasonable, my lord, understanding that a man of ordinary prudence will have? That no, it does not attract any legal consequence. There is no response also. And I knock the doors of justice, or rather, I approach the police authorities stating that you have permitted a dharna at that point of time at the same venue. Yes, if there is a violation, if there are criminal proceedings, I will definitely not have a right. I know the concept of negative equality. But your ladyship kindly appreciates. Or an action spoken of, not leading to any consequences, is not considered to be mandatory. Here also, my lord, similar is the action.
Does it make much of a difference from the north gate to the south gate?
But I am exercising my fundamental right also, as well as my right, my lord, of having a legitimate expectation. It's a very simple case, my lord. Had it been a case, I am, my lord, again repeating, my lord, that there was a prosecution, my lord, launched owing to the violation, I would not have any case. And my lord may kindly appreciate also, my lord, the further bias and the vindictiveness that the state poses, my lord, towards the petitioner herein. Even insofar as the alternate sites are also concerned, at the inception also, my lord, when the case started today, the state came up with a negative answer that no, not permissible. But I am not a terrorist. I am not a my lord, fugitive. I have availed of the legal recourse and knocked the doors of justice after, my lord, failing to satisfy the authorities who are competent to accord a permission. That look here, you accorded a permission or you permitted a particular demonstration which ran into a lack of people for a period of 5 days. I also, as a citizen of India,
This is, you said, DIG's office.
but the DGIG's office.
DGIG's office.
One is in Novanno and the other one is in Bhavani Bhavan. Now, there are two offices.
Is Bhavani Bhavan under 144 restriction also?
Well, Bhavani Bhavan, well, the difficulties, your lordship,
Very
knows,
narrow.
very narrow.
Very narrow space.
Very narrow space.
Yes. Then in front of Novanno,
So that's
Governor, I have handed over, my lord, that particular decision also.
well,
that
that
is the bus
decision,
stand.
that is only the bus
Bus stand of
Number one,
Novanno.
and number two, they were the government employees. But we had restricted them to one corner. Your lordship, to my recollection, that was also the direction at an extreme end of the bus.
And my lord, in so far as, my lord, the
Do you
decision,
want to hold it over there?
we wanted to hold, my lord, just opposite to, my lord, the DG's office. Be it, my lord, in Novanno or be it, my lord, in Bhavani Bhavan, my lord.
Bhavani Bhavan is a narrow place, you know. That is difficult.
My lord, I completely leave
Yes.
that, my lord, to the honorable court. And so far as the decision cited by Mr. Dotto is concerned, 69-1.
But I have
Supreme
not
Court
finished.
cases.
I have not finished with my.
No, he is not finished.
Oh,
I
right.
understand.
Oh.
But then
But I'll take instructions whether Bhavani Bhavan can be accommodated for 1 hour or so. And number two, but I don't want to say a lot
1
of
hour.
things which my learned friend has said. RTI application he has not pursued. If I have not
I
answered,
have made
he had an appeal, right, an
I-
appeal, etc.
this is
And in fact, Milord, again, not to be taken on record, but I don't want to make submissions which
the court knows that you will not make any unreasonable
but on 9th
submissions.
of
This
October,
is the expectation also.
but on 9th of October, matter was mentioned before the Honorable the Chief Justice at the first sitting, praying for orders in respect of whatever was going on.
আমি করেছি
Let us not go into that. The Honorable Chief Justice was pleased not to entertain.
But to the best of
But I
instructions.
do not know who was the petitioner.
No, no, but,
Whoever.
but the
Whoever.
petitioner was not there.
Then
but
there
I
is
did not
nothing on
mention it.
record. Was it oral? Was any petition was filed? Whether there is an order of the court? Nothing is there. So we do not know anything.
But it was brought to the judiciary's notice.
Oh,
The individual, my lord,
On
is
But
not-
let us not go.
yes,
Let us not go
since
into that.
there is nothing
But
on
I'll try to, my lord, use my offices so that, my lord, on a
Bhavani Bhavan.
Bhavani Bhavan,
I completely bow down, my lord, to whatever
I
falls
try
from the
to,
honorable
may I
court.
come
my lord.
back tomorrow with the incident?
Whatever falls from the honorable court, my lord, I bow down to that, my lord. I am a law-abiding citizen, my lord.
Wait.
I do not flout the law.
Wait, it's a negative answer.
Rani Rashmoni Road is
I am
here, my
not
lord.
begging for my rights, my lord. It is not that the state will give me arms, my lord.
Why Bhavani Bhavan is not possible?
But it's so narrow, my lord. The court is there. Criminal court is just
No, on a weekend.
on a
Weekend. When the court will not be functioning.
থানা এই ছুটির দিন শনিবার বা রোববার আচ্ছা may I come back tomorrow 10:30? May I come back tomorrow 10:30?
Why 10:30? Not 10:30. 10:30 there are other matters.
Any time suitable, my lord.
What steps will you take against the violators? Tell me first. Then we'll look at what is to be done to the petitioner.
Grateful.
But as of now, my lord, we have not taken any steps.
Why don't you take steps? Now it has come to your notice that a violation did take place. And this is a cognizable offense.
No. But again, my lord, I cannot make those submissions because it may be amounting to protecting someone. 188, my lord, its application has been interpreted by the Honorable Supreme Court as to where is the application and to what extent is the application. I cannot, my lord, say more than that.
You mean to say you cannot take any steps against
no.
the violators?
The situation under which 188 can be applied,
Any section 188, 288, 388. What step will you take against the violators? If you cannot take any steps, then others will also do it.
very well. But then in that case, may kindly permit me to, my lord, complete my submissions.
That is a different thing. His permission is separate. Steps taken for violation is
But
separate.
there's no prayer to this extent, my lord. Therefore, my
No,
lord,
no, it
It
has
has
marched.
come to the knowledge of the
No,
court.
It has marched, my lord, also. Yes.
And this is one of the grounds for him to seek permission.
no, that is not the ground, my lord.
No, no,
That
that
is
has
the
marched.
It's an
application.
instance given by him to seek permission.
My application
Not
dated,
what he is saying today, that why have you not taken steps?
my lord, my
No, wait.
Madam.
Yes, one of the reasons seeking permission, right?
Hmm.
But then, do you not think that steps ought to have been taken? Today it is A, tomorrow it will be B, next it will be C. You are the mighty state, responsible for maintaining the law and order. Why will steps not be taken against the violators? Is it your case that there has been no violation? That
Lord-
is not the case.
Well, possibly, my lord, what my learned friend says, a
Don't forget about what your learned friend says. There is 144 restriction. Somebody has gone there. What will you do?
but then kindly permit me to, my lord, place one decision. Yes, please have a look to, my lord, 1970, volume 3 Supreme Court cases, my lord. Again, my lord, with this caveat, my lord, I make this submission, my lord.
Why the caveat? The moment you make a caveat,
No,
it means that there is a possibility by which you can sidetrack it.
no.
Why
On-
this caveat?
On a principle of law, I am saying this, that this may amount to protecting somebody's rights. That is what I am saying. But citing a
144
decision.
The more you stress on the fact that you will not take steps against the violators, the more decisions you rely upon, multiplication of precedents, it goes to show that you are protecting somebody. How do you come out of it?
My lord, a writ petition is filed to enforce somebody's right. If he has a right, my lord, he will enforce that right. If he doesn't have a right, he cannot come and say that why has the police not taken any steps against someone else. Let us put it in this way. His basic case is you allowed A, you allow B. Let us go by the first principles, Milord.
Yes, I have followed it.
Yes.
Tell me, had that demonstration been sought to be held by any other person or political party than the ruling dispensation, steps would have been otherwise or not?
But again, Milord, 188, Milord, its applicabilities would come into play. 188, the words of 188 has been interpreted by the Honorable Supreme Court. Please have, I'll not place the decision. Please have a look to 2 paragraphs of this decision because I don't want to place it. 1970 ভলিউম 3 প্লিজ লিখিস না এটা লিখিস না আমি এটা আমি অফিশিয়ালি সাইট করছি না সাইট করছি না
ডিল করতে হবে তো
না তোকে ডিল করতে আমি এটা প্লেস করছি না তো বলছি
সাইটেশনটা না বলে দেখবো কি
please have a look to para 23 and 27 for yourself, Miller. I am not citing this decision.
If a decision is not cited, Manoj, how can Manoj?
You have your SEC online or what? 1970?
I'm awaiting.
But I
1973 SEC 746. Madhu Limaye.
746. কোন প্যারা দাদা?
23 আর 27
বার করো।
23.
Yes, Miller.
তাড়াতাড়ি বলো।
Please take the last 5 lines
Yes.
of 23. And first sentence of 27.
Would you please explain what it means, the last 5 lines? If such disobedience causes obstruction, annoyance, or injury to persons lawfully
To the
employed. What
persons, for example, police.
causes obstruction, annoyance,
Annoyance or
or
injury to
injury
persons
to-
lawfully employed.
Yes.
Lawfully employed in that place or area. I'll give you another example. Say, Milord, the security guards at Raj Bhavan. It had caused annoyance. Let us keep the police aside for the time being. See, the security guards posted at that gate of Raj Bhavan who are the employees of the government. So a person lawfully employed, if it causes obstruction, annoyance, injury to those persons.
So if there is no allegation of obstruction, annoyance, or injury, so it is permissible.
Milord, that is why, Milord, I did not want to cite this decision. Milord.
No, but then once you have
I'll tell you,
brought it to the notice of the court,
definitely.
what will be the
Only,
conclusion?
Milord, to answer my learned friend's point that why 188 was not applied because it is an infraction of 188. Now here the Supreme Court says that ipso facto is not a ground. It is to be coupled with some other. That is why.
And paragraph 27 you said?
Yes, first sentence. This is more clear. Therefore, Milord, that's why I wanted to.
Manoj, I
Did not
completely
want
rely
because
on this judgment as well, Manoj.
that
I
would.
have a better case now.
Yes.
I'm grateful to the learned advocate general.
Therefore, Milord, I say, Milord, it may amount to protecting somebody's right.
Tell me one thing. The 144 order restriction, the restrictive order is there. What is the area around the Raj Bhavan where this 144(2) applies?
144 টা কতটা?
Radius of 500 meters na 1000.
How many meters?
আপনি রাজভবনের দেয়াল থেকে কতটা পাইলেন এটা একটু বলুন।
5 meters, 10 meters from the
No,
outside wall of Raj Bhavan.
what I understand is the precincts of entire Raj Bhavan.
How far does the
Yes,
precinct
of the width.
extend?
The width, Milord, I'm told, Milord, from so far as the north gate is concerned, from Telephone Bhavan till Milord the Raj Bhavan's north gate. Now this side, এই দিকটা কতটা? মানে আমাদের হাইকোর্টের দিকটা? Old Court House Street. Entire Council House Street. আচ্ছা ওই দিকে আমাদের ময়দানের দিকে? মানে মানে উল্টো দিকে boundary অব্দি। But on the other side, towards the Maidan gate, possibly the south gate,
Hmm.
till Milord the Maidan.
But then the Y channel falls possibly
Wise channel is much more than that.
it's far off
If your
from there.
lordship takes Milord the east gate of Raj Bhavan,
Yes.
it's just in front of the road which leads to Milord KC Das.
KC Das.
On that road, in between the Raj Bhavan's gate and KC Das, somewhere in the middle. So maybe around
So, but then
60.
the distance that you said it falls. Suppose from the north gate to the telephone bhavan, the distance. Then if the same distance is applied in the east gate, then the Y channel will fall within the 144 restrictions. No,
that part, it's not what you are equal.
equal distribution is not there, so it varies.
These are actually Milord strategically Milord imposed. Strategically,
All right.
like your lordship knows, Milord, in College Street, Milord, there's a 144 imposition at times to protect that university gate and all that. So it depends upon the position of that place as well. It may so happen, Milord, possibly, I do not know, just speaking from my.
Suppose if they hold the demonstration, say 10 meters from the north gate towards the telephone office, do you all have any objection to that? Would you all have any objection?
But that, Milord, would be within the 144 then.
Within 144 there.
No, but then at least 10 meters he'll leave and then hold.
But the entire road where I'm told.
Emergency will not be there. There is no emergency position right now.
বাঁদিকটা।
Towards the telephone bhavan, you said.
What Mr. Banerjee is suggesting, from Raj Bhavan's gate, if I walk towards Telephone Bhavan, that road is under 144. There is a lane on the left hand side in between Raj Bhavan's gate and Telephone Bhavan. হ্যাঁ, ওই যে
ঘুরে যাচ্ছে এই নর্থ গেট থেকে এটা সোজা চলে যাচ্ছে
হ্যাঁ।
এই গেট টেলিফোন আমারটা এইখানটা
Which one? From Kiran Shankar Rai Road
No.
towards the left? No.
opposite the Raj Bhavan's north gate.
Opposite the Raj Bhavan's north gate. There is only one road which goes straight to the telephone house.
ওখানে গাছ চিনতেছে আগুনটা লাগবে কোন জায়গাটা বলুন
I don't think that my officers over here has the authority to take decision.
Yes. You take appropriate instruction from the authority. 10 meters from the north gate, any difficulty?
Well, could I suggest, Milord, I'll try
Yes.
to persuade my clients. Immediately after the 144 area,
সাউথের সামনেটা
Then they'll go to the Ganges gate. They'll go over there. No.
এই দিকে ছিল তো রাস্তা
And my case is very simple, my lord. Now, my lord, it gets bolstered by virtue of the decision cited by the learned Advocate General, 1970, volume 3 SCC, page 746.
এই রাস্তাটা
One is 188, he says, my lord, cannot be imposed unless and until there is some violation. We want to do a peaceful demonstration. A very peaceful demonstration. It is there in my application.
প্রপার এই বিলে প্রপার নিবি
হ্যাঁ?
প্রপার নিবি
কোর্ট যা বলবে তাই করবো, স্টেট যা বলবে তা করবো না।
আমি যেটা বলছি আমি কি বলছি তোকে रोपन में भी citizen
How long will the demonstration continue?
As my lord directs, my lord.
No, no, it is your choice. The
Whatever-
court will say, do not demonstrate.
Could I say this? But again, my
You
lord, with
say, what do you want? What exactly is your prayer?
My lord, we can do it for 48 hours also. We can do it for a day as well, my lord. Whatever, my lord, the honorable court deems reasonable.
No reasonable.
No, since my lord, this is since my
Then
lord,
leave
this is
it.
my lord.
because today, my lord,
So much
my lord,
time is consumed in
my
this
learned
matter.
friend's client is entitled to do politics. I don't stand in the way. No, this is a closed chapter. They have gone before the division bench.
Whatever.
Division bench, my lord, has
If my
no,
if
yeah,
my
give me
client
No,
is
no, don't
entitled
go.
to do politics, then my lord,
Tell me
an
for
apple of the
how
eye of
long?
the state, my lord, is not also entitled to flout the law.
How long?
My lord, may kindly grant.
Instructions? 6
Madam,
hours?
My lord, may kindly.
By 6 hours?
My
By
lord, may
the
kindly grant me 5 minutes, my lord. Pass it over for 5 minutes. I'll just come back.
but I'll come
No,
back
no.
with instructions tomorrow because my lord, my officers over here cannot. My lord,
My lord, 6 hours.
6 hours. And 10 meters off the north gate?
My lord, exactly at the place, my lord, where it was held.
Why
We will,
exactly
my lord,
at
we
the
will not be
place?
constructing any makeshift judge. Or my lord, let the state file an undertaking before the honorable court that in the future, my lord, no one will be permitted, my lord.
No, that the court will take care. But then just not in front of the gate, you leave 10 meters and then
No. Yes, we'll.
but 10 meters, I think the road itself is 20 to 25 meters.
which one?
The road which goes towards from KH Road to Great Eastern, that is more than 30 meters.
No, the distance what I was saying is you have the gate
Yes.
and you have the telephone bhavan. There is a lane.
Yes.
So from the gate, they will leave 10 meters and then they continue with the sit.
Gate.
North gate.
But then it will in the middle of that road.
Where just the opposite side of the road, then they can start. The Red Cross building is over there. The
in front of Bankshal Court.
not Bankshal
Because
Court.
Bankshal
No,
Court-
not Bankshal Court. The registry
But I-
office.
But I-
Registry office.
but I think we
Registry
are
office is there.
Bankshal Court is rastata.
Registry office is there. Bankshal Court is the other one.
Huh.
Beyond that, it's not the Bankshal Court. The registry office is there.
yes. Registry office is towards
Just
the
the
west.
opposite side of
Not exactly
the
opposite. Anyway,
diagonally opposite
diagonally.
to the north gate. The opposite side of the footpath in that case.
But I believe, my lord, from my side, my lord, it's better your lordship decides this matter.
We will decide it so that nobody in future can
Yes.
come up with the same plea. But let this be over.
My lord, if this is over, my lord, this again becomes another instance for C to come.
No precedence.
That does not.
That is why, my lord, my learned friend has cited Anindo Shankar or Anindo Sundar Das.
Yes.
That the court,
Anindo Sundar Das nahi.
yeah, whatever.
Anindo Gopal Mitra.
To say that, my lord, previously the High Court had permitted. Kindly do not permit that, my lord. Your lordship
That's been
decides. this, my
cited
lord.
before the Honorable Supreme Court also.
Definitely, definitely.
One of the most celebrated decisions of our court.
Tomorrow you want to come back? Both of you?
Tomorrow.
1:15 I'm fixing it.
No, my lord, kindly permit me to finish this matter. My lord. I take it up at 2 o'clock. Oh, 2 o'clock, there is a different bench.
Postpone আছে 8 নম্বরে কালকে।
Tomorrow, my lord, there is another bench. Please
এখানে
take it
করুন,
up.
আমি তাহলে ওখানে করিনি, CISF বাড়িনি।
Kindly,
learned friend
kindly
Raghu
take it
my
up
lord,
day after.
postpone matter
No,
for
I'm
3 days.
I'm on legs over there. Let him not say that. I'm on legs. I'm addressing the court over there.
1:15 will be all right?
I'm sorry, my lord.
1:15 will be all right?
But could it be day after, my lord?
Day after? 1:15.
Give me some time, my lord. 150, my lord.
For hearing? No, not hearing. Only to fix
Kindly
up the
hear-
date
kindly-
and time sheet and then after we'll
kindly
see
hear
what
me,
is
my
to
lord.
be done. No,
Kindly hear me, my lord.
I will hear you. Certainly I will hear you.
But if the permission is granted, my lord, thereafter, my lord, it becomes academic so far as I am concerned.
Not only you are concerned because further follow-up steps may be required to be taken. The court may pass directions, may not pass directions. That will be only upon hearing the parties.
Right.
Not that without hearing the court will pass direction. But since a prayer is there for by the petitioner and the
But the prayer is to allow.
to allow,
him.
and this
The decision.
No, of
the
course.
decision appears to be a vague one. I could have quashed it here and now, but then resending it means a further writ petition will come because you will not allow.
I
It is
cannot
not
allow.
sufficient.
My
You
lord,
cannot
my lord,
allow.
may I apply the
You
principle of
cannot allow.
my lord, may I apply the principles of K.S. Jagannath.
So in that case, that is the reason I wanted, let them do it for 6 hours at a place which does not, let us see which place you all, the court
Wait,
can
wait,
pass
I'll
direction
speak and come back.
day after tomorrow.
Yes.
You also come back on that
Correct.
date.
হ্যাঁ।
এই রাস্তা
এই বইগুলো ফেরত যাবে, please record an order. Her detailed submissions made on behalf of the parties. Stop.
কোন?
Advocate, sorry.
এই আমি ঠিক
List on 27th June 2024.
এই এখন দেখবো না পরশু দিনকে আবার
না না তোকে যেটা দেখ
না না তুমি আমাকে নিশ্চিত করো তুমি বারাসাত করে
List এর
পাঠিয়ে
নিচে
দিচ্ছি ডাইরেক্টরে ব্যাংশাল কোর্ট
115 লেখা থাকবে
দেখ যেটা কারণে আমি বলছি ওটা ঠিকই আমি বলেছি তুই
at
ওটা দেখ।
115
আমাকে তো ভুল ভুল করে
রাজভবনের উল্টো দিকে বসে
PM.
যেখানে ভাইপো বসেছিল আমি সেখানে
ঠিক আছে?
যেখানে ভাইপোদা বসেছিল সেখানে ভাইপো
Hey, yes,
এগুলো
for details.
থাকবে।
I'm grateful. আরেকটা